Good afternoon, class. We will be continuing with our lecture on the law on sales. Our source materials are indicated in the description of this video. So anyway, may napansin ako sa aking channel analytics. So half of the viewers of my videos dito sa channel na to ay hindi pa rin nakasubscribe. So anyway, sana lang naman konting support sa inyong prof at mag-subscribe na kayo. Malay ninyo, good karma, bigla kayong pumasa sa board exam. So ako kasi, pumasa na ako sa bar exam eh. So, kayo, meron pa kayong board exam na iti-take. So anyway, malay nyo, always rooting for my students, especially yung mga magte-take this year. Hopefully, matuloy na, pero hindi ko pa rin alam, baka mamaya reset na naman, etc. etc. So anyway, good luck to all of my students. I've heard they have been watching my videos on the Revised Corporation Code of the Philippines and also sa sales. Bakit kaya sa sales? So anyway, let us continue with our lecture, specifically Chapter 6 of the law on sale. So chapter 6 will talk about actions for breach of contract of sale of goods. So obviously, we are talking about goods here. Ano ba ang goods? Very simple. Ang goods will include all chattels, personal, but will not include choses or things in action, meaning rights. So it will not include also money of legal tender in the Philippines, but it will include growing fruits or crops. So yun ang example ng goods. So also for this chapter, we will not be this chapter will not apply to sales of real property. So kung merong breach doon sa sale, breach doon sa contract of sale of real properties. Remember that chapter 6 will not cover these kinds of breach. Ang kino-cover lang nito ay breach ng contract of sale of goods. So anyway, governing laws, what is the governing law for actions for breach of the contract of sale of goods? Ano ba ang law na susundin natin? So obviously, governed primarily by the provisions of the law on sales insofar as they are applicable. And take note again, class, that as I have already stated, this chapter is not applicable to the sale of real property. So take note of the actions which are available under this chapter. On the part of the seller, an action for the payment of the price. So obviously, seller can collect the price if the seller is not paid by the buyer. What else? Action by the seller for damages for non-acceptance of the goods. So here, dun pa lang sa pag-deliver ng goods, hindi na tinanggap ng buyer. So obviously, dun pa lang, the seller can ask for damages already. But syempre, recovery of the price not available to him because wala namang transfer of ownership, and yun ang tandaan ninyo dyan. So anyway, subject to qualifications as we move into discussions of 1595 as well as 1596. Also take note of the action available to the seller for rescission of the contract due to breach thereof. Obviously, yung seller can rescind the entire contract because of breach committed by the buyer. And letter D, the buyer can also file an action for specific performance in case the seller refuses to deliver the goods. In 1599, a buyer has a right to file an action for rescission or for damages in case of breach of warranties of the seller. So yun ang actions available in case of a breach of the contract of sale of goods. Didiscuss natin isa-isa. 1595, seller's right of action for the price. So here, seller is recovering the price of the goods. So in number 1, if the ownership to the goods has passed to the buyer, so meron ng delivery sa buyer. The buyer has accepted delivery. So when goods are delivered to the buyer, buyer accepts delivery, ownership is transferred to the buyer, but the buyer does not pay. So if the buyer wrongfully neglects or refuses to pay the price, seller can file an action for the price. Collect sum of money, collect the price. What else? Ano bang example nito? Buyer, seller, they agree to enter into a contract of sale of typewriter. Typewriter talaga. Nahalata tuloy yung edad ko. Abutan ko pa yung typewriter nung bad ng mga elementary ako. So anyway, here class, merong typewriter. The typewriter is delivered to the buyer. The buyer accepts delivery, but the buyer neglects to pay or refuses to pay for the typewriter. So what action is available to the seller? An action for the price. So collect yung price of the typewriter or yung goods. What else? Number 2, when the price is payable on a certain day and the buyer wrongfully neglects or refuses to pay such price, irrespective of delivery or of transfer of the title. So here in number 2, merong set na date para sa payment ng price and the buyer does not pay on the date set. So here, hindi pinag-uusapan kung na-deliver na ba yung goods or na-transfer na yung title sa goods. Ang point dito is, meron tayong deadline ng payment this day and the buyer does not pay. So whether or not the seller has already delivered the goods to the buyer or ownership has been transferred to the buyer, hindi natin pinag-uusapan yan. Ang sabi ko nga, ang pinag-uusapan lang natin, itong araw na to, bayad si buyer, di bayad si buyer. So remember class, the seller has a right to file an action for the price. So example, what day is today? Today is April 28, I think. So let us say that the buyer and seller enter into a contract of sale for, again, a typewriter. So to be paid for on May 5. So May 5 ang bayad ng typewriter. So anyway, ang delivery is, let us say, May 10. So nauna pa yung payment, no? Pwede naman yun. Depende sa agreement ng party. So anyway, on the agreed date of payment, which is May 5, the buyer refuses to pay for the price. So take note here class na ayaw bayaran ng buyer even if it is due already. Dapat niyang bayaran itong seller even without delivering yung goods pa. Kasi diba May 10 pa yung goods dapat i-deliver. He has a right to file an action for the price. But remember here, class, that the buyer is allowed to refuse to pay. So, pwede namang hindi talaga magbayad yung buyer on the due date if he is able to prove that the seller has no intention of delivering the goods on the day they are supposed to be delivered. So, in our example, the delivery date of the goods is supposed to be May 10. So, if the buyer can prove that the seller at any time before judgment doon sa action for the price na final ng seller, napatunayan doon ng buyer na the seller is unable to perform the contract of sale, he is unable to deliver, or he does not intend to perform, or he does not intend to deliver yung goods, defense yan ng buyer. Bakit hindi ka nagbayad ng ganitong due date, etc.? Kasi nabalitaan ko na itong si seller, wala naman talagang balak na i-deliver yung goods sa May 10. and wala rin po talaga siyang goods na i-deliver na kasi ibinenta na niya sa iba, etc. etc. So that is a defense available to the buyer. What else? Number 3, when the goods cannot readily be resold for a reasonable price and the buyer wrongfully refuses to accept them. So itong goods na to, not readily sellable to the market. So hindi sila madaling ibenta for a reasonable price and the buyer wrongfully refuses to accept the goods. So even before ownership to the goods has passed, and take note here that the provision of 1596, which we'll discuss later on, are not applicable. So kung mahirap ibenta yung goods para sa for a reasonable price tapos ayaw pang tanggapin ng buyer, wrongfully, the refusal is wrongful. Remember class na even if the ownership in the goods has not passed, hindi pa kay buyer ang goods, pero the seller has a right of action for the price. Bakit? Kasi mahirap ibenta ito for a reasonable price. So malamang-lamang mahihirapan si seller to sell it to other persons. So example, buyer and seller agreed to yun nga buy and sell a typewriter. Sino pa naman bibili ng typewriter, di ba? So anyway, the agreement to pay and deliver is on let us say May 15. Yan na lang, May 15. So on the said date, let us say class that seller offers to deliver the goods to the buyer. So, yun ang napag-usapan nila sige, ito na, May 15 na, di-deliver ko na sa iyo yung typewriter. But the buyer refuses to receive the goods. So, anong gagawin ng seller? Seller must inform the buyer that he is holding the goods no longer as the seller, but as a depositary of the buyer. So, kumbaga, ilipat na niya yung ownership. So, ownership will be constituted by the seller on the buyer. And obviously, pagka nasa buyer na yung ownership, which has been constituted by the seller can maintain an action for the price. So, take note that this is possible if the goods cannot readily be sold for a reasonable price, and if the provisions of Article 1596, Paragraph 4 are not applicable. So now, based on the following discussions, on the previous discussions, remember class that it can be deduced that the seller cannot maintain an action for the price if the ownership in the goods has not passed to the buyer. So, pwede ka lang maningil ng price mula dun sa buyer. Kung ikaw yung seller, pwede ka lang maningil ng price mula dun sa buyer if ownership of the goods has already passed to the buyer. But there is an exception. If the price is payable on a certain day, so pwede kang mag-file ng action for the price if it is not paid on the certain day, as in paragraph number 2. What else? Unless the goods cannot readily be resold for a certain price and the provisions of 1596 paragraph 4 are not applicable. So here, you can maintain an action for the price if the goods are not readily resellable for a reasonable price. So, syempre, kung hindi madaling maibenta yung mga goods, hindi madaling maibenta yung mga goods for a reasonable price, take note here that even if ownership has not passed to the buyer, pwede nang mag-file ng action for the price ang seller. Anyway, as you've seen doon sa paragraph number 3 ng provision na ito, the seller may constitute yung buyer as owner of the goods. So, seller will hold the goods not as the seller anymore, but as a depositary of the buyer. And the seller may treat the goods as already delivered to the buyer. And yun na nga, ownership is transferred. So at that time, pwedeng i-maintain an action for the price of the goods. So yun ang tandaan natin dyan. Also in 1588, as an additional rule, title to the goods passes to the buyer from the moment they are placed at his disposal when the refusal to accept them is without just cause. So, upon wrongful refusal of the buyer to accept, so idadagdag pa natin sa paragraph 3 yan, bukod sa goods cannot readily be resold, tapos bigla, number 2, buyer unjustifiably refuses to accept them, and yun na nga, the seller is no longer holding the goods as a seller but as a depositary for the buyer. Etong mga circumstances na to, and also yung non-applicability of paragraph 4 of 1596 will entitle the seller to file an action for the price of the goods. So yun ang tandaan natin sa 1595. In 1596, seller will ask for damages. Usually this will happen if the ownership in the goods has not yet passed to the buyer. So hindi ka makaka-recover ng price. Anong pwede mong i-recover kung ikaw yung seller? Damages ang pwede mong i-recover. So number 1, if the buyer without lawful cause neglects or refuses to accept and pay for the goods he agreed to pay, the seller may maintain an action against him for damages for non-acceptance of the goods. So ayaw tanggapin yung delivery ng goods. So, the seller may maintain an action for damages. So, ito ang unang pwedeng gawin. So, if the buyer unlawfully rejects yung delivery of the goods. What else? Number 2, in an executory contract where ownership in the goods has not passed, and the seller cannot maintain an action to recover the price, the seller's remedy will also be an action for damages. So, the contract here is executory, meaning wala pang na-deliver, wala pa ring binayaran. And again, yung buyer refuses to accept the goods, etc. Wala pa naman kasi executory pa lang eh. So, ownership in the goods has not yet passed. So obviously, the seller cannot maintain an action to recover the price but is entitled to an action for recovery of damages. Number 3, if the goods are not yet identified at the time of the contract or subsequently after the contract has been executed, remember class that the seller's right is confined to an action for damages. Kasi dahil nga hindi pa naman identified at the time of the contract, so obviously, the seller does not know what to deliver yet. So, hindi pa niya alam. But take note here that the object must be identifiable in the future. So, kasi kung hindi identifiable yan without the need for a new contract, hindi siya determinate. And pagka hindi determinate ang object, void ang sale. So, take note of that. So, anyway, goods are not yet identified at the time of the contract or subsequently. Syempre, seller cannot deliver anything yet kasi nga hindi pa siya identifiable, so the seller's right is necessarily confined to an action for damages. So the measure for damages, paano ba ang bayaran ng damages? Ano ba ang basis niya? Is number 1, the difference between the contract price and the market price. So yun ang unang tandaan natin dyan. So yan ang unang basis ng damages. So estimated loss directly and naturally resulting from the buyer's breach of contract. So ito ang natural that is the amount of damages that the seller will naturally suffer as a result of the breach of the buyer of the contract. So difference between contract price and also market or current price. So remember class that damages will include not only actual loss but unrealized profit as well. Full amount of damage if there is no available market in which the goods can be resold at the time, the seller is entitled to full amount of the damage which he has really sustained by breach of the contract. So itong goods na to, wala talagang bibili eh. Hindi madaling ibenta. So kahit na gusto ng seller na ibenta sa iba, he cannot. So there is no available market for these kinds of goods. So the buyer should pay full amount of damages. So seller can collect yung full amount of damage which he has really sustained by breach of the contract. So lahat ng possible. So even possible loss of income or yun na nga kasi nga hindi naman talaga niya maibebenta yan. What else? Proximate damages. Under special circumstances, the seller is allowed to collect proximate damages. So that is a greater amount than the difference between contract price and market price. So ito ang contract price nila, ito ang market price nila. So usually yan ang measure ng damages. Contract price is 5 peso ay 50 pesos. O 5,000 na lang bawat isang typewriter. Pero nung binenta na lang sa market price dahil nga yun na lang ang halaga niya eh. Let us say 2.5 na lang. So the measure of damages is 2.5 applying the first rule. Now, if yung typewriter is not readily available or sellable in the market, 5,000 ang babayaran ng buyer, full amount of the damage. Tapos, proximate damages. So, under special circumstances, syempre, medyo mahirap ibenta. Sobrang dalang ng buyer, etc., etc. Pero bigla nakahanap ng buyer, pero yung buyer nasa Japan pa. So, kinailangan pag ipadala ni seller to Japan yung goods. Now, remember here, class, that the seller is allowed to recover proximate damages from the buyer. Kasi may special circumstance, may additional expenses. So, ang makukuha niya, hindi lang bastang yung difference between contract price and market price, but such greater amount to represent yung proximate damage. And remember also, class, that yung damages here, additional, na idadagdag nga ng court is because it may be reasonably attributed to the non-performance of the obligation. Had the buyer just accepted the goods, hindi na sana kailangan mangyari na pinadala po sa Japan, etc., etc., incurred additional expenses on the part of the seller. So, yun ang tandaan natin when it comes to proximate damages. Now, how about damages? How do you measure it? If in case the buyer repudiated or countermanded the contract of sale. So this is under 1596 paragraph 4. Buyer repudiated the contract of sale. So measure of damages is, syempre, you have to take into consideration the labor already performed and also expenses incurred for the materials before receiving notice of the buyer's repudiation. So, isasama sa measure ng damages yan. Magkano bang nagastos na sa labor? Magkano bang nagastos na sa mga materials bago i-repudiate ng buyer yung contract? What else? Also, take note that the profit which the seller would have realized if the sale has been fully performed would be taken into consideration to determine the measure of an amount of damages to be given to the seller. What else? Seller's right of rescission before delivery. So, merong right ang seller to rescind contract before it is before the delivery of the goods. So, obviously, if the buyer has repudiated the contract of sale, so on the part of the seller, di i-rescind na rin niya yung contract of sale and do not deliver anymore. Kasi nga, kahit na mag-deliver siya, ni-repudiate naman na ng buyer yan eh. So, the buyer will not recognize the contract as well. What else? Buyer has manifested his inability to perform his obligations under the contract. So, malinaw na sa seller that the buyer cannot pay for the goods. So, why deliver it still to the buyer? Siyempre, di ba? Dadagdagan mo pa yung problema mo kung dineliver mo pa. What else? Buyer has committed a breach of the contract of sale. So, if the buyer committed a breach, obviously, syempre, the seller can refuse to proceed with the contract. So, also take note of the notice requirement. So, a party to a contract which is who is injured by non-fulfillment may rescind yung contract of sale plus ask for damages. But obviously, class, the seller is required to give notice of election to seek rescission. So, yung election or yung choice to rescind the contract may be manifested in different ways. And obviously, formal notice of rescission is not required, but an action, bringing an action promptly for restitution is sufficient. So kung nagdemanda ka na for restitution of yung goods, etc., kung whatever it is, remember class here that that is enough notice, obvious naman to the buyer that you are already rescinding the contract of sale. In 1598, buyer's right to specific performance for breach of specific obligations. So, again, reciprocal obligations, as in 1191, injured party has a right to choose between fulfillment and rescission plus damages in either case. So, obviously, if the injured party wants to demand specific performance, hindi basta-bastang pwedeng i-cancel ng guilty party yung contract of sale. So, also in 1598, the buyer has the remedy of specific performance in case the seller fails to make delivery. So, also here, yung as seller cannot retain the goods on payment of damages. Anong ibig sabihin yan? Hindi na lang bastang pwedeng i-retain ng seller yung goods tapos bayad na lang siya ng damages. Hindi ko na di-deliver tong goods, bayad na lang ako ng damages. So, hindi pwede yung ganon. So, damages are imposed by law to ensure fulfillment of the contract and not to substitute for delivery of the contract, of the goods or performance of the contract. So, pagka grant ng court yung specific performance, syempre, the court will compel the seller to deliver the goods and he cannot retain it based on a promise merely of paying for damages. So, also take note that the court may impose such terms and conditions as to damages, payment of the price, and otherwise as it may deem just and equitable. So, what else here? Observe that the seller is guilty. Hence, there is no right of retention on his part even if the said seller is willing to pay for damages. So, deliver goods, yun ang kailangan. So, take note also that there must be an order from the court for specific performance, and note further that the court may make the order on application of the buyer. So, buyer files an action for specific performance, etc., etc. And that will be the basis of the order of the court for specific performance. What else? Remedies of the buyer for breach of warranty of the seller. So, grouped into 4 generally in 1599. Recoupment of or diminution of the price. So, yun ang sabi dyan. So, accept the seller's goods and set up the seller's breach to reduce or extinguish the price. So, buyer will accept the goods pero as a defense, para nga ma-reduce or to extinguish the price, he will set up yung breach of warranty by the seller. What else? Also available to the buyer is an action for damages for breach of warranty by the seller. So for damages, remember that the buyer must accept the goods and then again file an action for damages for the breach of warranty. So what else? Number 3, action. If buyer can also refuse to accept the goods and simply maintain an action for damages for the breach of warranty. Also, the buyer can rescind the contract by offering to return yung goods to the seller or by actually returning the goods to the seller and recovering the price from the seller or any part thereof which the buyer has paid to the seller. Take note that the remedies already discussed are alternative. So, once a remedy has been granted to the buyer, no other remedy can thereafter be exercised or granted. So, the exception to this is when the buyer has chosen fulfillment and fulfillment has become impossible, in which case the buyer may also sue for rescission under 1191 I think this is the second paragraph of 1191. So let us discuss yung remedies ng buyer, yung iba lang, hindi lahat. So anyway, recoupment in diminution of the price. So here, remember, there is a breach of warranty on the part of the seller. So nung dineliver ng seller kay buyer yung goods probably are let us say defective, so may breach of warranty against hidden defect. So syempre yung buyer hindi siya magbabayad niyan. Anong gagawin niya? Hindi nga niya babayaran yung seller. And syempre itong seller will file an action for recovery of the price. Yan. So yung buyer, meron siyang defense in case the seller files an action for recovery of the price. Bakit? Because there is breach of the contract. So pwede niyang i-avoid yung contract by and in case substitute in its stead a quasi-contractual obligation for the value of what he has received. So yung recoupment is synonymous but not quite. Hindi raw parang siyang discount pero hindi daw siya discount. Ang gulo nila, no? Pero ganun, babawasan din kasi, the effect is the same, babawasan din kasi yung price. So here take note class that noong pagka-deliver ng seller ng goods, nakitaan na ng damages ng buyer. But buyer is not bound to perform the contract on his part talaga actually because of the breach of the warranty of the seller. Pero dahil meron siyang natanggap na goods from the seller, let us say ano bang example? So, wala yatang example sa book ninyo, no? So, anyway, let us say ganito na lang. 20 boxes of apples ang binili ni buyer from the seller. I think this is the example of from your book. I'm not sure. So, anyway, yung 20 boxes of apples, let us say, is worth 20,000 pesos. So, anyway, all of them were delivered by the seller to the buyer. Upon opening yung mga boxes of apples, let us say yung buyer discovers that 5 fruits equivalent to 5 boxes yan are actually rotten. So bulok talaga yung mga apples na yan. So syempre, take note here class, buyer obviously can refuse to pay the price. He is not bound to perform yung kanyang part ng contract because there is a breach of warranty by the seller. Kasi pagkakita yung loob bulok pala, so hidden defect. So itong buyer refuses to pay. Now take note class that because the buyer has received something of value, he is under contract to pay it. So here, based on the quasi-contract of solution indemnity, bawal nga ang unjust enrichment. So kailangan niyang bayaran yung value of what he has received. Also, syempre, pagka nagdemanda yung seller for the price, syempre, itong si buyer, meron din siyang defense. Yung defense niya is the breach of warranty of the seller. And because of that, he can ask for recoupment in diminution of the price of 20,000 pesos. In which case, dahil 5 boxes nga ang sira, he will be allowed to pay, let us say, 15,000 only. Kasi nga, mayroong breach of warranty on the part of the seller. What else? Action or counterclaim for damages. So, buyer may refuse to accept the goods and maintain an action against the seller for damages for the breach of warranty. So, here, class, very important that the breach of an obligation will give rise to an action for damages. So, obviously, if the buyer accepts yung mga goods with the knowledge of breach of warranty, syempre, hindi na niya pwedeng i-rescind yung contract, pero pwede pa rin siyang manghingi ng right to recoupment or diminution in the price or also damages. What else? Rescission by the buyer is not allowed in the following cases. So, here, class, bawal ang rescission by the buyer. If the buyer yun nga accepts the goods knowing that there is a breach of warranty and the acceptance is without protest. Number 2, if he fails to notify the seller within a reasonable time of his election to rescind. Kasi remember, dapat reasonable time ang notification of rescission. What else? And number 3, if he fails to if he fails to return or offer to return the goods in substantially as good condition as they were at the time of transfer of ownership to him. So, kailangan, remember, rescission implies mutual restitution. So, the buyer should return the goods in the state that they were in at the time of delivery to him. So, if the buyer cannot so return, syempre, hindi na siya pwedeng mag-ask for rescission. But remember here, class, if the injury to the goods is caused by the defect which the seller warranted, the buyer may also still ask for rescission of the goods. Kaya naman kasi hindi ko na mabalik sa same condition as before dahil dun sa defect na winarat mo, na sabi mo walang ganyang klaseng defect. So, dahil may warranty ang seller na hindi siya defective, tapos defective pala siya, and the defective, yung defect na yon is the reason of the diminution in the condition or the injury or etc. Siyempre, pwede pa rin mag-rescind yung buyer. What else? Rights and obligation of the buyer in case of rescission. Siyempre, buyer is no longer liable to pay the price. So, kailangan na lang niyang ibalik yung goods. Pagka may binayaran siya, he may recover it from the seller. If the seller refused to accept the goods or refuse the return of the goods, syempre, buyer can hold the goods as bail for the seller. Also, take note that the buyer has a right of lien on the goods for any portion of the price already paid, and buyer pays a portion of the purchase price. Tapos, deliver na sa kanya yung goods, tapos itong seller refuses to accept yung return ng goods. So, with respect to that, yung buyer has a lien on the goods for any portion of the price already paid para ma-recover nga naman niya yung kanyang price paid. And he may enforce his lien if he were an unpaid seller. So anyway, that's it for Chapter 6 of the Law on Sales. Please stand by for Chapter 7, which will talk about the modes of extinguishment of sale. So anyway, thank you, class, and good afternoon.